Hello, everybody. Welcome back to Law, Liberty, and Logic. We have a fun show and discussion for you today. We're going to be talking about the common law citizens arrest here in Florida. And as always, when it comes to my educational videos, it is just that. It's just for informational purposes only. So if you have a legal issue, make sure you seek an attorney in your area so that you can get your issue heard. But this should give you a good sense of the backdrop to citizens arrest and give you some food for thought if you're just thinking about this for fun, or maybe you have a situation that you've been thinking about. It's a kind of a fun way to kind of dive into this issue and to think about what's going on with it. And make sure to subscribe to this channel if you're not already. Make sure to get that notification bell clicked so that way you can see our latest videos, as I'm going to be doing more videos with this live stream format to kind of engage everybody more and to be able to do more things and be able to present more legal issues for your edification. All right. So without further ado, I'm going to take a look at these key cases that kind of elucidate what the common law citizens arrest is all about. So this case here, Phoenix v. State, took place in June 21st, 1984. So it's an older case, but nonetheless still has pertinent aspects to it that is still in consideration today. So the Florida Supreme Court was ruling here, and which is very important because that's the highest court in Florida. So the information there is most applicable across all the different jurisdictions. And we'll see here what it is that citizens arrests often come up with when it comes to the legal issues that precipitate these arguments. All right. So in this case here, I'm going to start off talking about the information as presented. So it says, we have for review a decision of a district court appeal, State v. Phoenix, certified by that court as involving a question of great public importance. So they sent this up to the Supreme Court saying, this really important issue, and we really need to make sure that the Supreme Court weighs in on this. It says, we have jurisdiction from Article 5, Section 3B4 of the Florida Constitution. So they're just affirming here that the Supreme Court of Florida has this authority to be able to review this. It says, a certified question concerns the scope of authority of law enforcement officers to conduct citizens' arrests. And this is where you're starting to see where this often comes up. So you might be thinking, maybe these cases are just random citizens of Florida just grabbing people and arresting them. But actually, where this comes up most often is police officers who are arresting somebody outside their jurisdiction, right? They're maybe off duty, or they're just outside where they have legal authority to technically arrest somebody. And then they're there in court trying to defend themselves, saying, well, even if they didn't have jurisdiction, or, even if they're off duty or something like that, that they are able to make that arrest under the citizens arrest common law. So even as an off-duty person or being out of jurisdiction, they still had the right to make an arrest in a certain situation. So it's a really interesting and thought-provoking fact that these cases often involve police officers, even though it is a citizens arrest situation. Technically, a lot of times it's police who are trying to make these arguments for themselves as private citizens. So it says, we approve the decision below, which held that a sheriff and sheriff's deputies can make a valid arrest outside their jurisdiction, even though they have used their police car and have identified themselves as police officers when making the arrest. This case involves the arrest of petitioners in St. Lucie County by the sheriff and deputies of Martin County. On June 23rd, 1979, about 1 a.m., an officer of the Martin County Sheriff's Office saw some gasoline cans in the back of a camper covered pickup truck. Upon hearing the report of this observation, the sheriff of Martin County ordered officers to follow the truck. An officer in a surveillance airplane saw the truck enter St. Lucie County, but then lost sight of it. The sheriff and other officers of Martin County entered St. Lucie County, where they observed a fence gate upon which a chain had been cut and a new lock affixed. The gate was located at the entrance to a ranch, which the officers suspected was possibly being used as an airstrip. The sheriff and deputies waited there until around 6 a.m. when the surveillance pilot reported seeing an aircraft and two camper-top pickup trucks, but not the one that had aroused suspicion on the ranch grounds. The Martin County Sheriff then notified the sheriff of St. Lucie County of the suspected activity. The two pickup trucks were then observed departing the ranch, while moved north in St. Lucie County, while the other proceeded south into Martin County. The Martin County Sheriff and a deputy stopped the northbound truck in St. Lucie County, and guns drawn and blue lights flashing arrested the occupants. They discovered marijuana in the truck. The passengers of the southbound truck were arrested in Martin County. And of course, this is well before there was, the medical marijuana in Florida. So it was especially considered suspicious having marijuana then, even though I personally think it should all be legal. But that's the backdrop here. So the petitioners were charged with trafficking marijuana. They moved to suppress the evidence. The trial judge ruled that the stop and search of the truck in St. Lucie County, having been carried out by the sheriff of Martin County under color of office outside his jurisdiction, were unlawful. Right. So this is something to remember, that police officers don't have the ability to just go anywhere and everywhere willy-nilly and make arrests, depending on where they have authority for, in terms of legal authority. They may be restricted to a certain city or town. They may be restricted to a certain county. They might be restricted to a certain state, and so on and so forth. So that's an issue that, police officers have to work within those limitations. So the evidence found in the truck, along with evidence from the truck, from the aircraft, and incriminating statement were suppressed. The district court appeal reversed, although agreeing with the trial court the officers had no authority to stop and arrest the defendants in St. Lucie County. The district court reasoned that the officers might have properly conducted a common law citizen's arrest. So here we're bringing in that idea of a common law citizen's arrest. So common law meaning that it came through case law. It's not written by the legislature in statute. On motion for rehearing, the district court certified the following question to be of great public importance. Can an arrest be validated as a citizen's arrest? 1, if the arrest resulted from an intentional surveillance conducted by police officers outside the jurisdiction, utilizing a police aircraft and officers on the ground. And 2, if the police officers used a marked police car and asserted their official position in stopping the arrestees. So they say, we answer the question in the affirmative, that this is possible. So at common law, a private citizen could make an arrest without a warrant in certain specific circumstances. So as you can see here, the Supreme Court is about to outline these circumstances for which a common law citizen's arrest would be acceptable. And this is where it gets, very important to pay close attention, because if you don't follow it closely, you could be in big trouble because it is limited. So a private citizen does have the common law right to arrest a person who commits a felony in his presence. So first and foremost, a felony in presence, right? So you have to understand, you can't just say, oh, well, this person committed a felony, but I didn't see it, right? It has to be a felony in the presence. So you can't just willy-nilly say, well, I heard from someone, or, someone else, told me something and I have an inference. Nope. They have to be committing that felony in your physical presence. If you don't have that, you can be in trouble. And it says, or to arrest a person where a felony has been committed and where the arresting citizen has probable cause to believe and does believe the person arrested to be guilty. So also here, another important note is that a felony has actually been committed, right? And they have to have probable cause to believe and does believe the person arrested to be guilty. So the first one was, hey, they have to be in your presence to make that arrest. The second one here is that a felony has actually been committed. So it's not just, okay, maybe it's about to be, or, oh, it could theoretically be, or it hasn't been committed. It actually has to have been already committed. And then the person has to have probable cause to believe the person being arrested is guilty. So even though there was a time to obtain a warrant, a private citizen may make such an arrest and justify his failure to obtain a warrant by proving the person arrested was actually guilty of the felony, right? So that's important to note. You have to have those elements. Otherwise, you could be in trouble. So it says, common sense dictates that law enforcement officials, when they are outside their jurisdiction, should not be any less capable by virtue of the position of making a felony arrest than a private citizen. But because there are jurisdictional limitations on law enforcement officials' ability to make arrests, neither should they have any greater power of arrest outside their jurisdiction than private citizens. So again, officers could potentially make an arrest, but they have to follow the same rules as a private citizen when they're outside their jurisdiction. To prevent law enforcement officials from misusing the powers of their office and making a citizen's arrest, the courts of the state have held that law enforcement officials may not make a citizen's arrest under the color of law in their office. Unfortunately, this color of office doctrine is ambiguous and has led to some inconsistent results. At least one district court of appeal has held that a police officer is acting under color of law if his office, if he announces he is a police officer and displays his badge when making an arrest outside his jurisdiction. However, the majority of courts have disagreed, holding that the under color of office doctrine applies only to prevent law enforcement officials from using the powers of their office to observe unlawful activity or gain access to evidence not available to a private citizen. So again, police officers here using that authority to try to get investigative information that they would not otherwise be able to. The district court below followed, and we approve this latter line of cases. And applying the standard, the district court found the record also reveals, and the trial court did not find to the contrary, that at the time the occupants of the St. Lucie County truck were arrested, the sheriff and his officers had not asserted their official position for any purpose other than to make the arrests. So in other words, the police here didn't do anything else to try to assert their position except to make the arrest. The evidence upon which the arrests were based on was obtained before confronting any persons in St. Lucie County and without any unlawful assertion of official authority vis-a-vis the occupants or a third party. The district court concluded that trial court had erred in finding that the under a color of office doctrine applied simply because the officers had identified themselves as police officers when the arrest was made. The district court remanded for further proceedings on numerous other questions relating to the legality of stop, the search and the arrest, the admissibility of the evidence derived therefrom. We approve the district court's decision and remand for further proceedings consistent with the district court's mandate. So this case here kind of opens up our discourse here, just noting that there is a common law, standard for citizens' arrests. The felony has to be committed in your presence, or you have to have probable cause that the felony has been committed already. It's not just, it will be committed or it could be committed. It has to have already been completed for being committed, and you have probable cause for that. And police officers can't use their identification to kind of gather evidence and subvert anyone's rights otherwise, unless they saw those things, they met those standards, and then they just go make the arrest, right, if they're out of their jurisdiction. So very interesting here to see those limitations. Now, there's another case we're going to take a look at here that will help further elucidate the citizens arrest situation. So this is coming from the Florida District Court of Appeals for the 4th District. So this is not the Supreme Court of Florida, but it does give us some time since that Supreme Court case to kind of hear any nuances or changes or updates or more information that might be pertinent to making citizens arrests in Florida. Because this came later in August 24, 2016, and they do cite to some things since that time that helps give us a better sense of the ability to make a citizen's arrest. So in this case, we have a legal team versus Joe Bondi. Pamela Joe Bondi was the Attorney General at the time out of Tallahassee. So this case is going to, give us a sense of what those contentions were. Following the entry of a plea of no contest with the reservation rights, Luis Matos appeals the trial court's denial of his motion to suppress. We find the trial court erred in failing to suppress a portion of the evidence. Accordingly, we affirm in part, reverse in part, and remand for further proceedings. So in other words, there's something that needed to be suppressed that wasn't suppressed. The state charged Matos with felony driving under the influence based on his prior DUI convictions. Matos moved to suppress all written or oral statements made by the accused, the police officer, to the police or other state agents, and to whoever and to any person whatsoever arguing that the officer was outside his jurisdiction when he arrested Matos. So again, you can see here we're dealing with police officers, even though it's a citizen's arrest situation, because the police officer is acting outside their jurisdiction, and so they have to rely on the common law citizen's arrest in order to make their arrest valid. And that's why we get these interesting common law discussions, because of police trying to make arrests outside their jurisdiction. During a hearing on the motion, the state presented the testimony of Officer Andrew Pedrero of the Miramar Police Department. A lot of R's in these. The testimony revealed the following. Pedrero encountered Matos at about 11 a.m. when he was dispatched to 69th Avenue and Pembroke Road in reference to a driver passed out behind the wheel of a vehicle. The eastbound lanes of Pembroke Road at that location lie within the boundaries of the city of Miramar, while the westbound lanes are in the city of Pembroke Pines. So again, we have this jurisdictional issue. It's very tight because it's literally at the edge between these cities. Pedrero's department has a mutual aid agreement with the Pembroke Pines Police Department, but of particular importance, Officer Pedrero had no knowledge and was unaware as to any of the terms of the mutual aid agreement. Upon his arrival, Pedrero observed Matos' vehicle idling in the middle lane of the 3 westbound lanes of Pembroke Road. The vehicle was on the Pembroke Pines side of the border and facing west. There were other vehicles traveling on the road, and Matos' vehicle posed a danger to other drivers. Pedrero parked behind Matos' vehicle and activated his emergency lights to keep people from hitting him. Both the front windows of Matos' vehicle were rolled down, and Matos was passed out in the driver's seat with the ignition on and the vehicle in drive with his foot on the brake. All right, so very interesting. He's passed out in his car, and it's stalled, but it's in the middle of the road. So it's going to really key into what is valid for this arrest or not. A passenger was also passed out. Pedrero reached the vehicle, put in park, and turned the ignition off. Matos was still sleeping, and Pedrero tapped him and yelled at him to wake up. Matos roused, and an odor of alcohol wafted into Pedrero's direction as the two men conversed. Matos told Pedrero he was going to the Hard Rock or the Mardi Gras Casino, but Pedrero knew those establishments were located east, and Matos was headed west. Pedrero observed Matos' bloodshot and glassy eyes, so indicating here that he was drunk and passed out. Rescue units arrived, and responders spoke to Matos and the passenger. Upon their departure, Officer Pedrero directed Matos to exit the vehicle. Matos was unsteady as he walked toward the sidewalk, and he was confused, asking Pedrero repeatedly why he had been stopped. Officer Pedrero notified the Pembroke Pines Police Department of the situation, but officers were attending to a robbery and could not respond. Matos declined Officer Pedrero's request that he submit to a field sobriety test. So again, notice field sobriety test is different from breathalyzer. Very important to note because, with the field sobriety tests, of late, that's like them asking you to walk and turn around, stuff like that. You could refuse that potentially. But if you refuse the breathalyzer, right, then that's going to have its own set of legal issues. So not at the topic of this video, obviously a topic that could be dealt with in a future video, but field sobriety tests versus the breathalyzer and what you do or don't have to, comply with out there being certain types of ramifications. It's a very important discussion, especially for DUI attorneys. So, all right, Pedreo transported Matos to a breath alcohol testing BAT facility where Matos refused to give a breath sample. The trial court denied the motion, finding that there was a breach of the peace, which would give rise to an exception to the rule that a law enforcement officer may not make an arrest outside his jurisdiction. So notice here that this actually adds on something different. Before we just talked about felonies, right? If you have a felony that was committed in your presence, okay, you're good. Or a felony was actually committed and you have the probable cause to know that this person did do it and they're guilty of it. Those are felony exceptions that allowed someone to make a citizen's arrest. But notice here, this is a breach of the peace, and that's different. So we're going to be talking about that soon. So this on appeal, Matos argues that Officer Pedreo did not have the authority to stop and arrest him for a misdemeanor committed outside the officer's jurisdiction when the officer did not observe the driving pattern that constituted a breach of the peace. So notice here, it's not a felony this time. Citizen's arrest, we're dealing with misdemeanor. So that's much more limited. And now we have to figure out, okay, well, what's the common law misdemeanor citizen's arrest? He further contends that even if his stationary vehicle constituted a breach of the peace, Officer Pedreo could detain him but could not conduct a DUI investigation. But Matos also argues that there's no probable cause to support a DUI arrest. The standard review applicable to a motion to suppress evidence requires that this court defer to the trial court's factual findings, but review legal conclusions de novo. So in other words, they're not looking at the facts. They keep the facts they found, but they are looking at the legal conclusions that the trial court made. De novo means it's fresh. They're able to investigate and make their own conclusions, or a new conclusion if necessary. We first addressed Matos' contention that the Officer Pedro did not have authority to stop and arrest outside of his jurisdiction, right? So now we're looking at the authority aspect. Could the officer make an arrest of someone outside his jurisdiction? As a general principle, public officers of a county or municipality have no official power to arrest an offender outside the boundaries of their county or municipality, right? So this we're talking about before, a police officer, in and of their own police powers, they can't use that power technically outside of their legal boundaries, the county or municipality where they're an officer. So if they do so, then they have to start looking at if they have another opportunity as a private citizen to make an arrest. So it says, that being said, law enforcement officials have the same ability to make an arrest as does a private citizen when they're outside the jurisdiction, but law enforcement officials outside the jurisdiction do not have superior power of arrest than private citizens. So again, very important here to note that they have limited powers, only that of private citizens, which certainly is important because how would you delegate even an ability to do something if you don't even have the right to delegate it in the first place as a private citizen, right? So they were citing both a Second District Court appeal and Phoenix v. State, that Supreme Court case that we just read. So as you can see here, that case is still holding up from the Florida Supreme Court. At common law, a private citizen may arrest a person who is in the presence, who in the citizen's presence commits a felony or breach of the peace, right? So there's another Fourth District appeal case here, and we're starting to see the expansion beyond felony fleshed out. Admittedly, an officer may arrest an offender outside his jurisdiction when two enforcement agencies entered in a mutual aid agreement that permits the extraterritorial conduct by the outside police municipality. So in the Fourth District, at least, there could be potentially agreements with different agencies where a police officer may have ability to arrest outside jurisdiction if they had a special agreement with the other jurisdiction where maybe they're right next to each other, right? And that's a common thing. Oop, I lost my page. I see VLEX. Let's close that out. Oop, doop. Oh no. Hold on. Dun, dun, dun. Got to go back. There we go. Okay, there we go. Sorry for that. Oh, and it just went back to me. Oh, that's unfortunate. Okay. That's why, because it has an active link and I keep clicking it. I meant to, take out the page. All right, we are back. Okay, so here we go. This power, however, is circumscribed by the color of office doctrine. The under color of office doctrine pertains only to prevent law enforcement officials from using the powers of their office to observe unlawful activity or gain access to evidence not available to private citizens. So again, Police can't just willy-nilly do anything they want just because they flash their badge. They can't go into a jurisdiction they don't have permission to be in and make arrests, and then just use that to get access or evidence that's not available as a private citizen to do. So the doctrine should be viewed as a limitation of the power of police to conduct investigations and to gather evidence outside their jurisdiction. When officers unlawfully assert official authority, either expressly or implicitly, in order to gain access to evidence, the evidence must be suppressed. So, however, this doctrine does not prevent officers from making otherwise valid citizens' arrests just because they happen to be in uniform or otherwise clothed with an indicia of their position when making the arrest. So again, officers could be in uniform, they could be outside jurisdiction, but they have to be falling under the private citizen common law arrestability if they are outside their normal boundaries of jurisdiction. So that's why it's very important that they don't do anything that subverts that if they want to get the evidence. If they do something that goes outside the bounds of their authority to try to get evidence, well, they're going to be in trouble. Right? So they have to meet the criteria for making the arrest and just make the arrest. In the instant case, Officer Pedreo detained and arrested Matos for DUI, a misdemeanor, right? So he arrested him specifically for DUI, and that is a misdemeanor. It's not a felony. So already, okay, we're not dealing with the felony situation for citizen's arrest. So what are the limitations for misdemeanors? Although Officer Pedreo testified that Miramar and Pembroke Pines Police Department had a mutual aid agreement, he was completely unaware of the contents of the agreement, and the state failed to introduce into evidence a copy of any such agreement. Thus, that exception to the general rule barring extraterritorial arrests does not apply, and that the state failed to present any competent evidence as to the substance of the mutual aid agreement between the two cities. So in this case, maybe he would have had a mutual aid agreement that would have allowed him to do something like that with the other police department, but the state did not provide evidence of it. And because they didn't provide evidence of it, and the court is only reviewing the legal standard, not the facts, that doesn't count for anything. So they can't rely on a mutual aid agreement. They can only rely on the citizen's arrest aspect. So the pivotal issues then before us are whether Matos' conduct amounted to a breach of the peace, giving Officer Pedreo grounds to effect a citizen's arrest, and whether the officer at any point acted under color of law rather than as a private citizen. So this is where we're getting into the misdemeanor aspect. So it's the breach of the peace that enables a citizen's arrest for misdemeanor, right? So it's very narrow and limited. It's not just any misdemeanor. It's breach of the peace. So you have to follow that very carefully. And that's where it gets very tricky and very risky for people if they try to just effect a citizen's arrest and it's not a felony committed at presence, and it's not a felony that has already been committed and they have the facts for it, and they know, that they have probable cause this person did it. Okay, well, you better be careful about what is the breach of the peace that you make an arrest for, because otherwise you could be in trouble. So breach of the peace is a generic term including all violations of the public peace, order, or decorum. A breach of the peace includes a violation of any law enacted to preserve peace and good order. And again, they're citing a few different places here. But in Edwards, this court found the defendant's erratic driving, which forced the drivers off the road, was a breach of the peace. So in other words, a breach of the peace counted in another case that, someone's driving erratically on the road. They're scaring people. Okay, that's a interesting thing that might rise to that. So Judge Glickstein observed that physical harm is not an element of breach of the peace. We cannot think of a more apt illustration of such breach of the individual and collective peace of the people in Okeechobee County than to have a drunk driver at the wheel of a killing machine that is going all over the road and scaring oncoming drivers to death rather than killing them. What is petitioner's view of breach of the peace? Is it that the drivers of the oncoming vehicles who were forced onto the berm should have been forced completely off the road or actually hit? So he's being sarcastic here. The judge is just noting that, breach of the peace doesn't mean, you actually have to physically harm somebody. Scaring people by driving across the road and threatening them and they're dodging is clearly a breach of the peace. And I would have to agree that you're driving on the wrong side of the road, oncoming traffic, and people are having to swerve to not hit you. That is certainly a breach of the peace. So in a subsequent case, an appellant sought to distinguish Edwards, arguing that the mere act of drunk driving without actually forcing vehicles off the road or otherwise endangering motorists or pedestrians is not a breach of the peace, right? So, that's interesting, right? There's one thing to be scaring people on the road because you're driving all over it. That's another to be like, okay, you're drunk, but maybe you're not actually threatening anybody, right? Okay. The court rejected the argument, noting that other jurisdictions that follow the common law breach of the peace rule for citizens' arrest have found that operating a motor vehicle while intoxicated constitutes a breach of the peace. Oh, okay. So other jurisdictions here said that, well, even if you're not threatening people because you're not driving all over the road, if you're DUI, driving under intoxicated and you're in your car, that could be a breach of the peace. So thus we find the officer Pedreo observed a breach of the peace. Okay, so just by being drunk in his car, it counted. Matos was found passed out in the driver's seat of a vehicle that was stopped in the middle of traffic. Okay. The passenger was also passed out. The car was in drive and Matos' foot was on the brake. Matos emanated the odor of alcohol. It strains credulity to assert these circumstances did not pose a threat to the safety and order of the public. We do, however, agree that Officer Pedreo acted under color of law when he began conducting a DUI investigation. Indeed, a private citizen would not have been permitted to lawfully administer a breathalyzer test and conduct field sobriety exercises. This court has recognized that if an officer gains access to evidence using the powers of office, he has acted under color of law. By merely approaching Matos in uniform and activating the police car's emergency lights, Officer Pedreo was not acting under the color of law. So again, he could put his lights on and just let people know, hey, this guy stopped in the road. But beyond that, he's limited. Recognizing that an officer does not run afoul of the color law doctrine by detaining a person while wearing a police uniform, operating a police cruiser, and activating the blue lights. So, however, once Officer Pedreo attempted to have him submit to a breathalyzer and perform field sobriety exercises, he was seeking evidence only available to him in his capacity as a law enforcement officer. So just note here, if someone were to see that person passed out in the middle of the road in their car, could they stop them, right, as under a breach of the peace citizen's arrest? The court says yes. In fact, you probably could just have that person move off to the side of the road so they're not in the middle of the road, that kind of thing, just preserving the peace. But to go beyond that, right, could a private citizen then be like, you have to submit to a breathalyzer or field sobriety test? No. So they're making it clear that's clearly a law enforcement function that a private citizen could not do, because that goes beyond just the making an arrest and holding someone, in a safe place until they get picked up by police for a breach of the peace. So in this case, the court is making a very fine line between his ability to stop the person and hold them off to the side safely and being able to go further to get evidence for a DUI arrest. Matos also argues that Officer Pedreo lacked probable cause to arrest, but this argument is misplaced. Because Officer Pedreo observed a breach of the peace, probable cause is not necessary to affect a citizen's arrest of Matos. So this shows you right here, there you go. Just the being drunk and in the car in the middle of the road was enough to say, okay, you could affect a citizen's arrest under breach of the peace. In sum, the trial court erred in denying the motion to suppress, but only with respect to evidence gathered by Officer Pedreo once he began acting under color of law, i.e. when he asked Matos to submit to a breathalyzer, transport him to the BAT station, and requested him to perform field sobriety exercises. Matos requests a discharge on remand, but we declined to do so. The state stipulated that the ruling was dispositive, apparently operating under a good faith belief that a ruling granting the motion would have been dispositive. Normally, when an appellate court finds a trial court erred in not suppressing evidence and the ruling seemed dispositive, we reverse and remand for discharge of the defendant. In other words, letting him go. Here, however, we are affirming in part, and thus under these unique circumstances, we remand for further proceedings. Because again, the arrest for breach of the peace was valid, but not the rest. So there is still something to charge him with. On remand, Matos shall be given the opportunity to withdraw his plea. Any arguments not addressed in our opinion are without merit. So as you can see here, just narrowly talking about this from the perspective of the DUI. And again, it could be further distinguished down the road, like what happens if someone is in front, at the wheel of the car and they're drunk, but they're, who knows, maybe they're off in the middle of nowhere or they're on private property kind of thing, right? There are potential nuances and arguments to be made down the road to say, well, that's not really a breach of the peace. But for now, for most intents and purposes, if you're out in the public road and you're drunk at the wheel and you're passed out, you're probably going to be able to be arrested at least for breach of the peace and whatever else might come if the officer has jurisdiction. And I'm not going to go into it in depth, but I just want to note that this here, the breach of the peace statute, is just something to know. 877.03, this is the Florida statute, it's the latest one. It says, breach of the peace, disorderly conduct. Whoever commits such acts as are of nature to corrupt the public morals or arouse the sense of public decency or affect the peace and quiet of persons who may witness them, or engages in brawling or fighting, or engages in such conduct as to constitute a breach of the peace or disorderly conduct, shall be guilty of a misdemeanor of the second degree, punishable as provided in other subsections. So I just want to point this out because breach of the peace is kind of open-ended, and I'm not going to get into all different ways to breach the peace. But I do want to emphasize that by and large, when it comes to a private citizen's arrest situation, the breach of the peace aspect is probably most commonly going to be affected for brawling or fighting, right? That kind of situation. That's really where you're probably going to see the citizen's arrest. Maybe you're at a bar or your restaurant and all of a sudden people are engaging in fighting. They're fighting each other. They're drunk or something like that. That's where this is really meant to come in. that you're making a citizen's arrest of somebody to stop the fight. You're restraining them from attacking each other. And, that's clearly a breach of the peace because it's two people having a bar fight or fighting in a restaurant, something like that. That's, public affray. That's where it's going to be most clear. Where it's not going to be very clear is what is public morals or public decency and affecting the quiet persons, because there's also First Amendment issues, right? There's going to be legal nuance where you're protected in certain modes of communication or displays and things like that. And that gets very tricky. So that's why, the misdemeanor breach of the peace aspect gets more tricky for a citizen's arrest situation. The felony, at least a little bit more clear because that's, felony level thing is a much more egregious situation. But again, you always have to be careful because if you get it wrong, you're going to be in trouble. You are going to, get in legal trouble potentially for assault, battery, kidnapping, potentially, all kinds of things that can come out of that if you make a wrongful arrest. So, if someone's deciding to step in on something, they better be very sure that that was really a felony, that the person really did commit it, that kind of situation, or that it's a real breach of the peace, something like people are actually engaged in a bar fight kind of thing. And you're, helping maybe with others to restrain those people and hold them back from each other until whatever police come and they get charged or taken or something like that for fighting for, public affray. But it's a fun idea. It's a fun concept to play with and think about that, there is a common law way to make a citizen's arrest in Florida. And if you do follow the law, you should, be otherwise relatively okay if you actually followed those standards. But those standards are limited, right? They're not unlimited. It's not like you could just do anything willy-nilly. And your specific situation is always going to be, nuanced. So it's something you want to be careful about. And if you get into some hot water situation with that, you might, want to be talking to an attorney who deals with criminal defense situations and making sure that you have that defense, for yourself, that you had the, whatever the common law citizen's arrest ability, in that situation if you fall into that. So hopefully that helps, gives you some food for thought. Interesting legal discussions and discussions of how the nuanced law might work. And of course, there's way more that could be discussed with it because there's more cases and more nuances and this, that. But I just wanted to kind of, get really narrowly focused on some of the basics of it, just to give you a head start on that and thinking about it if you're just personally curious, or maybe you're in law school and you're researching things, or maybe you're in a situation you're just starting to look at this and thinking about it and you're getting ready to call an attorney. Those are some of the considerations that you're going to talk about with your lawyer if you're needing to deal with that type of case. So I appreciate y'all coming on by and listening and hanging on out. And again, please do subscribe to the channel. Please do upvote this, share this. The more support I get and the more viewership, the more it encourages me to do more of these videos and covering these issues. And I just really enjoy it myself too. So it's just a lot of fun to, kind of wade through the laws and see, how it is that you're able to protect yourself and protect your rights and fight back against injustice, in a way that, you stay safe in the process too, and don't get into more legal hot water by doing something that you're not supposed to do. Right. All right. Well, thank you so much, everybody. And I will talk to you soon on the next stream.